Wrong, Quickie. Here's another bad one. Heien v. North Carolina. Yep, another one from my home state. Basically, an officer's screw-up can provide reasonable suspicion under the Fourth Amendment. Maynard Vasquez was driving on I-77 with Nicholas Heien asleep in the back seat. Officer Matt Dereese thought Vasquez looked nervous, so he followed him. Eventually, Vasquez slowed down when he got behind a car going slower, as you do. Dereese saw that one of the brake lights was out and pulled Vasquez over, believing that this was a violation. It was not. According to North Carolina law, as long as at least one brake light is working, you're good. After Dereese pulled him over, he escalated the stop to a search and found cocaine. The pair were arrested. Heien filed a motion to suppress, which the trial court denied, but the Court of Appeals reversed. They sensibly ruled, an officer's mistaken belief that a defendant has committed a traffic violation is not an objectively reasonable justification for a traffic stop. The North Carolina Supreme Court reversed it, saying that the Eighth Circuit had concluded that such a search was reasonable. Funny thing, North Carolina's not in the Eighth Circuit. It's in the Fourth. And the U.S. Supreme Court confirmed that 8-1. Chief Justice John Roberts apparently used the legal loophole of nobody's perfect, and apparently ignored the legal adage, ignorance of the law is no excuse, at least when applied to police officers who are supposed to be trained on the law. Kagan's concurrence was even worse, saying that the court could have concluded that the stop was valid, therefore the search was valid. Sotomayor actually wrote a decent dissent for once. She pointed out that, of all the case law the majority relied on, they all hinged on the officer being wrong on matters of fact, not of law. And that was the really bad thing about this decision. She wrote, "There is scarcely any law which does not admit of some ingenious doubt. One wonders how a citizen seeking to be law-abiding and to structure his or her behavior to avoid these invasive, frightening, and humiliating encounters could do so. There is nothing in our case law requiring us to hold that a reasonable mistake of law can justify a seizure under the Fourth Amendment, and quite a bit suggesting just the opposite. I also see nothing to be gained from such a holding and much to be lost." And the result of that is more lenience towards officers, which can only result in more abuse.